Yes, Mr Hay.
Thank you, my Lord. As my Lord is aware, this case concerns children, so I will endeavour to anonymise their names, as did the judge below, and not to refer to the parents or indeed any other feature in the case that might identify the children.
Yes. Well, I'm sure all present in court appreciate that if any names are inadvertently revealed, that doesn't mean to say they can be published.
Thank you very much, my Lord. I, together with my learned friend Mr Heifer, represent the appellant mother in this case. Mr Heifer was trial counsel for the mother and settled the skeleton argument in support of the appeal. My learned friends to the far right of Counsel Drone, Mr Turner, Queen's Counsel, and Mr Bennett represent the respondent father in this appeal. Mr Bennett being trial counsel. Both my learned friends have signed off the skeleton resisting the appeal. An intervention has been allowed by Reunite, and they are represented by my learned friends Mr Setright, Queen's Counsel, and my learned friend Mr Guha, who sit to my right. My Lords, this is an appeal against the order of Mr Geoffrey Kingscote, Queen's Counsel, sitting as a judge of the Family Division of the High Court, where he was considering and determining an application by the father under the 1980 Hague Convention for the summary return of 3 children to the Kingdom of Spain. He acceded to the application and made a summary order for their return. Permission was granted to launch this appeal on all the grounds contained in the grounds of appeal by order of my Lord, Lord Justice Baker, on the 7th of July 2022. My Lords, there are 3 subject children to this appeal. A, who was a girl born on the 10th of August 1918, so she's, 2018, she's therefore 3, 4 very shortly. T, who was born on the 14th of September 2019, 2, rising 3 next month. And then B, who was born on the 3rd of January 2021, who's therefore now 19 months of age. There is also another child who is, we would say, significantly affected by the outcome of this appeal, who are the children's half-brother. The children's half-brother R, born on the 12th of April 2016. He's therefore 6. He is a child of the mother by a previous relationship. My Lords, the appellant challenges the decision on 2 fronts. Firstly, in respect of what we say is the failure on the part of the trial judge to hear oral evidence on the issue of consent. We don't launch an attack on that, on the issue of consent by itself, although we may draw attention to the way that the judge dealt with the issue of consent when dealing with the overarching question of whether or not he should have heard oral evidence in determining that matter. The second part of our appeal is to challenge the judge's approach to the mother's Article 13b case. That's Article 13b, the grave risk of physical or psychological harm or intolerable position. And we submit that his approach was fundamentally flawed, and this court ought to set aside his determination that the mother's case failed. Fundamentally, we say that judge failed in respect of the Article 13b matter. He failed adequately to evaluate the risks facing these children on return if the mother's allegations were true. Effectively, we borrow a phrase of my Lord, Lord Justice Moylan, that the judge fell between 2 stools. He did not consider the risk to the children if the allegations were true, nor could he, and indeed did he, confidently discount the possibility that the Article 13b risk may have been established if those allegations were true. My Lord, I'll come in more detail to the genesis of that particular expression by my Lord Justice Moylan when I take my Lord to the authorities. We say as a result of that error, he allowed himself to become distracted from considering what effective measures should be put in place to protect the children from the risk that we submit he should have been satisfied they would meet in a return if the mother's allegations were true. We also challenge his determination on the basis that it appears that he failed to consider the Article 13b risk and the allegations that the mother presents to establish that risk in a holistic or cumulative way. Instead, he considered the allegations in a straight line way, item by item, without considering the totality of the allegations, and therefore, and most significantly, the totality of the risk that the children would face if they were to be returned to the Kingdom of Spain. That error meant that had a knock-on effect on his analysis of the protective measures that would be required. We suggest and submit, looked at those protective measures item by item on a straight line basis, rather than cumulatively to assess whether those protective measures were adequate and indeed effective to protect the children from the Article 13b risk. Perhaps a good example of that, and I'll come to this in more detail later on in my submissions, is his assessment of the risk facing the children if the mother's allegations of domestic abuse were true, and also her allegation that if the children were returned, she would be destitute, and there was a risk that the Spanish authorities would then intervene and remove the children from her care. It's one thing to say that protection against domestic abuse might, one way of protecting against that risk might have been to be satisfied that the children and the mother were living in a separate household to the father. We challenge that in any event, just dealing with the risk of domestic abuse. But the point I'm trying to make is the cumulative effect on that. If one assumes, for the sake of this example, that separate households may have done the trick, the judge should have then gone on to consider the second point that I've just made, which is the risk of destitution, which is the mother's case. Because we would submit that if the risk came about and the mother was forced into destitution and therefore worried or very concerned about the attitude of the Spanish authorities, and we say they've made it abundantly clear that they would intervene and remove the children, and I'll take my lords to where they've said that in a moment, but the lack of proper financial support of the father and his inability, indeed refusal, to make the necessary financial support would have, in fact, increased both the risk and the need for protection, because in those circumstances he would have used his financial clout or the use of financial support as a weapon to control the mother and thereby put the children at risk of further domestic abuse. My lord, I give that as an example of what we submit is the failure of the judge to look at everything cumulatively. To use different language, the language of Lord Justice Henderson in a case re P that is referred to in our skeleton rather perhaps unhelpfully as re GP, we submit that he, the judge, failed to examine in concrete terms the situation the children would face if returned to Spain. And concrete must incorporate the cumulative point that I've already made. And in particular, whether the proposed protective measures would actually ameliorate, mitigate the risk, and therefore protect the children from the Article 13b risk. We make a final subsidiary point in our appeal that if the judge was not satisfied that he had complete information, as indeed was the case of the trial judge in the repeat case that I've already alluded to, then he clearly had the option of adjourning the case to direct more information be obtained. We don't in any way detract from our primary submission that he was wrong to have rejected the Article 13e case put forward by the mother. But if, in the eventuality that he thought that he didn't have sufficient information, he should have adjourned the case. He should have adjourned the case to direct either the parties or third parties to provide the essential information that he himself needed in order to carry out the task that he had to do, which is to examine in concrete terms the situation the children would actually face on the ground from their perspective in Spain. My Lords, with that overview, I'll deal very briefly with the facts, as I'm sure my Lords will be aware of the overall narrative arc. There is a feature, though, of the case that I do wish to underline. As my Lords know, the mother is British. She was born on the 16th of September 1998, so she's now 23. But she had lived in Spain with her family only since she was 16. She left school with no formal qualifications. She didn't go to school in Spain. The father is Moroccan, born on the 1st of August 1985, so he's just celebrated, by my calculations, his 37th birthday. He says he has lived in Spain for 20 years. You'll see straight away that there is a significant age gap between the parties. In fact, on the father's case, the parties met when the mother was only 12. The mother says, in fact, they met in 2016, when R was a few months old. Small point, I think, in her statement, she says she was 19, but by my arithmetic, she must have only been 18. The point, though, is that the mother was, in our submission, vulnerable. And whilst that isn't a particular part of the test for Article 13b, or indeed to determine how the Article 13a consent issue should be determined, it is, in our submission, a pervading feature of the factual matrix of this case, particularly when my Lords go on to consider that all 4 children were living with the mother's family. That's her mother and father, the children's maternal grandmothers, until they chose to leave Spain in September 2019, when the mother was only 21 and had just given birth to her 4th child. The result of all that, we would submit, is that the mother was left isolated in Spain in an abusive relationship with a significantly older man, far more experienced man, a man who had lived in Spain far longer than her, had much better language skills, and knew his way around Spain, both geographically and around Spanish procedures. And we would suggest that given that dynamic, it's highly probable that he would have been able to take the lead in dealing with the Spanish authorities on behalf of both of them, and when in due course I propose to take you to various documents generated by the Spanish social services, I'd invite this court to bear that factual feature very much in mind. As my lords know, between September 2020 and April 2021, all 3 children, B hadn't then been born, were removed into foster care in Spain and remained in foster placements until April 2021. Essentially, the Spanish social services were concerned about neglect, the inability of both parents to meet the children's basic physical needs in terms of feeding and clothing, and the safety of their home. They were concerned with the unhealthy hygienic circumstances that those babies found themselves in. And also, perhaps of more significance to these proceedings than in any related care proceedings, there was a huge problem with documentation. That casts its shadow on the immigration issues that we put before the court as part of the Article 13b case, in terms of residence permits, and also just life in Spain generally, making sure that services, benefits and the like were properly accessed, proper accommodation. That is all brought into issue. Now, my lords, by way of factual background, it appears common ground, and therefore...
Sorry to interrupt you. You've given us an overview of your case. What order are you seeking from us?
Well, if you...
in the event that your appeal were to succeed?
If it succeeds on the question of oral evidence, well, plainly we accept there has to be a rehearing. As I've already indicated, we can't make a direct challenge on the Article 13a consent substantively, but what we do say is that the judge should have heard oral evidence. Plainly, my lords can't hear oral evidence, and so it must be, we would submit, remitted so that a full-time High Court judge of the Family Division should hear oral evidence and determine the Article 13a consent issue, we would say with respect, properly. My Lord, we would say that if we succeed on that ground, all of the case should be remitted. But we suspect that the court would also this court would wish to deal with the Article 13b case too. And if that appeal is successful on that ground, then plainly both matters would be remitted for a rehearing before the status of judge that I've already identified.
Thank you.
My Lords, it's common ground that both parents discussed and agreed a plan for the family to move to Britain. Mother says that father even wanted her to give birth to B in Britain. It seems common ground that British passports were obtained for the children. Perhaps somewhat surprisingly, or at variance with the difficulties that they had formalising their status in Spain with the Spanish authorities. There appears to me, obviously I'm new to the case, no information or no disclosure from the Secretary of State as the type of visa that the father applied for. But we're assuming that it was for some sort of long-term visa because the plan was to live here. We may be wrong, it may have been a visitor's visa of short-term duration. We simply don't know, and neither does the court. It's common ground that the father was unsuccessful in obtaining that visa. And much we would submit turns on those issues as to whether or not the father withdrew that consent. On the 23rd of August of 2021, I think it's common ground that the mother moved to England with all four children, and has remained here ever since. My Lords will see that Cornwall Social Services have been involved, have made a social work assessment. The family is now on a child support plan. Mother has been given her own property independently of her own family. My Lords, how I propose then to develop my submissions is to deal with Article 13b first, principally because we say it colours the whole case, and in particular the issues that the judge had to decide under Article 13a. We propose to look at I propose to deal with it in sort of 3 stages: to look at the evidence, to look at the legal principles, and then to see how the judge dealt with the case. But perhaps, slightly getting ahead of myself, I should have already just confirmed with my Lords that you have a core bundle of documents, an authorities bundle which I think was submitted at some point last week by the parents, certainly before my involvement started. There is then a amended supplemental bundle of authorities which was supplied by the intervener, but had inserted into it 2 authorities which I apologise were my was due to my intervention at 8 and 9 of that bundle. So I
don't think we have that bundle.
Well, that's what I'd understood.
I don't think any of it. We've got the authorities bundles in 2. The one that was filed,
yes,
is in 2 bundles. But that we don't have the supplemental bundles of authorities to which you just referred.
Right. I'm told that the intervener did lodge it with my Lord Justice Moylan's clerk. I know that there was some discussion about this before my Lords commenced this appeal. It is, I suspect, important that my Lords have that.
I think it is.
My Lord,
yes.
My understanding, having briefly investigated this matter, is it was lodged electronically.
Right.
But the indication, or at least the understanding after a discussion, was that a hard copy lodging was not required. If a hard copy lodging is required by my Lords, then of course we will do our best.
You can see I don't have a screen in front of me. So yes, it is.
It plainly is, my Lords.
What's in it?
Quite a lot.
Right.
We've summarised in our skeleton the principal matters.
Yes.
But
we clearly need. So can it be arranged?
Yes, it may not
with?
be instantaneous.
No, it won't
but those behind me will do their best to get. Would it be all right if it was limited to 3 hard copy bundles? Because I think that my learned friends are operating electronically.
So I've got it electronically, and that suffices for my purposes.
It sounds as if they're happy.
Yes,
but
yes.
Plainly,
Three,
the Lords
thank
must have
you.
it. I apologise if there was a misunderstanding.
Right, don't worry.
And I apologise, I perhaps should have raised this issue 20 minutes ago, but I didn't, so apologies to that. As I say, we inserted those 2 extra authorities into that bundle, so I think 2 might have been. I saw an earlier bundle, I don't know whether that reached my Lord, it probably didn't, but there are 17 numbered separate authorities, and there's 407 pages in that bundle. And I think it starts with the practice guidance. Both the guide to the Hague Conference Guide to Good Practice, and then the practice guidance given by the former president.
No.
My Lord, I can perhaps take things in a slightly different order if hard copies haven't.
Just so you know, the bundle of authorities that I think we all have starts with the convention itself and then the explanatory report. We don't have the domestic practice guidance.
No. My Lord, I think looking at my electronic copy, that goes to 442 pages.
Yes.
So I appreciate it's quite a weighty tome.
It is.
my lord, let's progress as quickly as I can. Can I then invite the court to go to the core bundle for this appeal? And I propose I hope briefly, to take my lords to the evidence. My lords, just for reference, at page 92 of the bundle, my lord will see, I'm not going to invite my lord to look at the detail of this statement, if that's what it is, but on the 3rd of May, the mother, when she was in person, before she had funding, filed this document. This is one at page 92. My lord, I don't propose to take my lord to any of the detail in this, but just invite the court to observe what the mother was saying and what her concerns were at that stage in a very general way. But as I've already submitted, the mother is vulnerable. She didn't have any legal support at this stage. And really, I'd invite the court, as far as the substance of her case on which this appeal is grounded, to concentrate on her evidence prepared by those instructing me that appears at page 120. And I propose to take my lords to where her case is set out in respect of Article 13b, which starts at page 125 and paragraph 22, where she introduces the main features of her Article 13b case because of the abuse of herself and the children. It's important in my submission to note that her case is not limited to what might be called simple domestic abuse inflicted on her, but it very much extends to the children. And then she expresses her concern about the lack of resources. And then at paragraph 23, body of her statement, she develops her case on domestic abuse and control, what he would make her do or not do, call her fat and ugly, threaten her, scare her. Then controlling behaviour escalated. She explains that was particularly the case when the children, the 3 elder children, so not B, were taken into care. And then he began to lock her in the house. Then he began to control the children, not allow them to play with toys, take them outside. 24. He would hit me, chuck me around. This was when she was pregnant with B. He was physically violent despite me being pregnant, she says. Very difficult time. Violence would occur when he was drinking. And like a lot of vulnerable mothers in her situation, she was too afraid to report this to social services or the police. And she gives the reason there. And she explains why. In my submission, not an uncommon feature of domestic abuse cases in this jurisdiction. Father had more control over me, she says at the time, as I felt like I couldn't do anything about his behaviour in case it meant social services would keep the children. It was only when she managed to flee him that she felt safe. Then at 26, I'll continue to be controlling and abusive, continue to hit me. This is after the children were returned. He would lock both me and the children in the house. We say that's abuse of the children. That's important when I come on to analyse the judgment. She points to how dangerous it would be. And then there's another point at the conclusion of paragraph 26, which has some bearing on the consent issue in general. And what we say is, and I'll come to this in due course, is one of the main reasons, if not the main reason, why the judge should have heard oral evidence in this case. He continued to do this right until the point when I left for England. And then she gives an example, she gives very clear evidence, actually located on a specific date of the calendar. The day we flew to England, he locked me and the children in when he went to his work, as he always used to do. And he had to come back to unlock the door to let me and the children out. She says I had to call him because of the flight. He came back and he told me to go. Now, that needs to be unpacked quite carefully, and I may as well make this submission now. In terms of the oral evidence point, that we say is clearly something that the judge should have given the mother an opportunity to explain. I accept that it could go both ways. The judge might have found that wholly inconsistent, internally inconsistent with her case. On the other hand, he might very well accepted her case as being internally consistent and as being quite conclusive, if not compelling evidence, that the father had consented in accordance with the legal test to the children relocating to England. Over the page, I hope I can take this quite quickly. She then reiterates some of the points about her fear the children are returned to Spain, the abuse will continue, escalated over time, and how it had escalated to locking the children in. Repeats the point about being violent when she was pregnant. Then there's more evidence about the control and the impact on her, and how the children will react if they're aware that their primary carer is living in a state of fear of their father. And then at 30, even, my lords, even since the mother has been in England, he's continued to upset the children, threatening to take them abroad. I'll come on to what else he's done since she left for England in a moment. She describes her fear. And then 31, I'll come to it straight away. Since she fled Spain, father sending messages on social media harassing me. He sent me messages on social media saying that I would not get away from him. She explains why my lords, and indeed the judge below, doesn't have to trawl through pages and pages and pages of written messages. She doesn't have her phone. Unfortunately, another common feature my lords might consider of cases involving vulnerable parents. Then there's an escalation over the page at paragraph 32. On the 11th of May, on the eve of the court proceedings, he still couldn't control himself. He even threatened to kill the mother. Then she deals with what she told her social worker. Paragraph 34 leaves domestic abuse and deals with the lack of basic necessities. Inability to meet the children's needs. She doesn't believe the father has a job. As I'm sure my lords will be aware, that is crucial in the court's assessment, or the judge's assessment, of the effectiveness of the protective measures that he offered to provide financial support. She also says he doesn't have his own accommodation, staying with his brother. Indeed, I've already outlined how the main concern social services was neglect. Never had enough money to feed them, pay the rent. She repeats, didn't receive any benefits, father was not working. She's worried there's not enough money, either for food, for accommodation. And at 35, she essentially puts him to proof. Produce the evidence, she says. Produce the evidence that you've got a job, and you've got some money, you've got some income. And she gives specific evidence about a previous promise. She develops the theme about money, which I've essentially summarised. 36. She says at 37, father's said, I think in his statement, she could get benefits. She gives evidence. She did not get any benefits when she was living in Spain before. She explains why, with the assistance of her English solicitors. She explains, and I don't think this is really an issue over the page, but with 4 children, 6 and under, realistically she can't generate her own income by working. There's no evidence that she's ever worked for remunerative employment, apart from odd bits of work at her parents' bar that she accepts. She calls that work experience towards the end of 37. She doesn't have any qualifications where she hopes to get back to college. 38 again repeats the point that father doesn't have the means to pay. Not enough money for food or buy them clothes or rent, that there's a real risk that the children would suffer directly because of that. But also, to be developed later, that I've already touched on, that Spanish social services would intervene by removing the children again into foster care. Father suggests that she can return to the flat previously rented. She says that he was kicked out of the flat for not paying the rent, and she doesn't think it's still available. And it was only a 2-bedroom flat anyway. And there's 4 children. My lords, she then develops a concern about being abducted to Morocco, which I'm not relying on for this appeal. So, my lords, that is the evidence of the mother. My lords, I ought to just take you to some of the objective evidence that the court did have from the social services reports. I hope I can do this comparatively briefly. At 201 is a child in need social work assessment from Cornwall Council. And if I can invite my lords to go straight to page 211. So that's the name of my client, the mother, at the top of the page that she uses in her dealings with the local authority in England. So under the box, what did they tell you? Mother says initially she didn't want to talk about the family experiences. Wholly predictable, we would respectfully submit. She went on to say the children were in care for a year because of neglect. Deals with negative drug test results. And then this is an explanation just above, or just at the end of that box, the 27th of September 2021. Mother explained she's in a violent and controlling relationship with the father, refused to allow her access to money, locked her in the house. She and the children relied on her parents in the UK to pay the rent and the other bills. That, in our submission, summarises her case. My lord, while we're looking at this report, can I just deal with a point that's made at 219? I'll just take you there first, which is about the view of the Spanish court apparently saying that the father is a protective factor. This needs a bit of careful reading, if I may respectfully say so. It's consultation with a Central Spain specialist social work advisor at the British Embassy on the 8th of November, who told the social worker in England that presumably the local social services in Spain had told her, that's Miss Ruiz, that the father of the youngest children started the process for recovery order, etc. And then second paragraph, concerns in Spain were in relation to the mother's alcohol use, with father being assessed as being the protective factor when the children were released from local authority care. We can find no reference to that in any of the Spanish social work documents that are in the bundle. My Lord, just for the sake of completeness, as we're here just over the page, you'll see a further description of what the mother's case was in the first two paragraphs there. Perhaps the third as well in respect of, and that's tied into the elder, I think, of the subject children, A. My Lords, if I can briefly deal with the third strand of the 13B case, which I accept straight away is not evidenced directly in the mother's written material, and indeed was only raised comparatively late in the day by my learned junior, when he had taken over from the initial trial counsel at the adjourned hearing, and was instructed a very short notice. You may have picked up from the judgment that there was a difficulty with the original counsel instructed having COVID. And he did raise the immigration issue. And in our submission, there is a serious immigration issue that needed to be considered. And we particularly raised this issue in respect of the need for further information. Of course, it was only raised late, as I've already explained. But the factual position, I think this is agreed, is that neither the children nor the mother actually have, as we stand here today, any formal documentation or permission to remain in Spain. Now, we understand, and one can check this just by going online, that as with anyone else in this court, we would have a right to visit Spain for 90 days in every 180 days. But in our submission, even considering, and we do, or bearing in mind as we do, that a summary return under the Hague Convention is only for a limited purpose, we would still respectfully submit that that is wholly inadequate for dispatching an Article 13B case based on a very real immigration difficulty. We submit, therefore, that there's no automatic right for this mother and these children to live in Spain beyond that normal visitor's permission. And
the evidence is that they are British nationals and Moroccan nationals. Is that right?
I'm not, certainly British nationals, because they've got British passports. Yeah, we accept that they're entitled to Moroccan nationality by dint of the...
But not Spanish?
Well, we checked this. Well, I do. I can answer my Lord's question. But
okay, there's no evidence.
Well, my Lord, our researchers, and this may be wrong, but there's no automatic, and I underline automatic, right for children born in Spain to be Spanish nationals just by dint of them being born in Spain. Plainly, if their parents are Spanish, that's one thing. And we understand that there's also a provision that is similar to our immigration rules, that perhaps not in this respect, but if their parents are from various Latin American countries, that they would have or could have an automatic right based on descent from parents of that nationality. But I want to be very cautious about that. There's no evidence, expert or otherwise, of that. And that's just a matter of information and information only. But that's a matter, that's a point that I don't want to dwell on overly. It's another feature that should have been looked at cumulatively with the other difficulties, indeed the risk that we say the children would face if they were to return. And it raises the spectre of the children being or achieving some sort of immigration status that is different from the mothers, and the risk of separation in this case is, we would respectfully submit, self-evident if that were to occur. If it were right that there was a potential risk of separation, that would give rise to a 13B risk, which should have been considered further. And we accept that there might be out there expert or other evidence that would help the judge protect the children against that risk. And my Lord, that leads on to the final 13B point we make in this appeal, which is again, it's a cumulative point that there is a risk that the mother will be prosecuted, arrested, perhaps detained in Spain. The father did make a denuncia. Despite being asked to do so, he had not, by the date of trial, removed that. That is a risk. The risk is of separation from the children's perspective, going back to the concrete measures that need to be looked at on the ground when the children return. My Lords, I was now going to dip very briefly, I hope, into the quite considerable authority of the Supreme Court and of this court that has built up on this issue. My Lords, I don't propose to take the court to Article 13B itself, and unless it would assist, nor directly to the Supreme Court decision of Re E. But perhaps I can take my Lords, my Lady, to the authorities bundle and a case of where my Lord Justice Moylan gave the lead judgment, which is at page 276 in the main bundle in Re A.
We don't have Re E anyway in this.
Oh,
Do we?
Yes.
yes, I think it is.
Re E is tab 9.
171.
Tab 9, yes, thank you, Crosses. I think it might be helpful to start with that, wouldn't it?
My Lord, I was going to take a shortcut in the interest of time by taking my Lords to those parts in
Is it
my
repeated?
Lord's passage in Re A, but
Does it
Re A.
Because it just sets out.
Yes. Well, my Lord, I'm
I think it would be helpful to start,
very
just
happy
if you don't mind.
to do that, my Lord, of course. My Lords, perhaps starting with, there's a long, as my Lord will know, there's a long, it might be called an introductory section of the Supreme Court speech in the first 27 paragraphs. Perhaps unless you want me to go any earlier than paragraph 29, I can
So I
start
think
it
it's
off.
where,
Paragraph 29.
yes, where it sets out the approach
Yes.
to be taken to Article 13B.
Yes.
Not the grave, not the burden of proof, but the assessment of risk.
All right. Well, my Lord, 29 is where Baroness Hell starts her analysis of Article 13B. Perhaps then I can quickly move on to paragraph 32, which deals with the burden of proof. But it lies on in this case, the mother, the respondent who opposes the child's return. It's for them to produce the evidence to substantiate one of the exceptions.
Yes,
We
it
submit
would really
we've
be
done.
appropriate to hear all evidence of the allegations made under Article 13b.
Yes, thank you, my lord. I'll come to that issue
Yes.
in a moment. Rarely, but not never. Paragraph 33, the risk must be grave. And then there's a relationship between the seriousness of the risk and its likelihood. Over the page is analysis of physical or psychological harm. It's perhaps worth stressing what Baroness held, how she characterised intolerable. Means a situation which this particular child in these particular circumstances should not be expected to tolerate. As we bear that very much in mind and submit that the three subject children, in fact all four children, would face that intolerable situation if they were to be returned. Paragraph 35 emphasises that Article 13b looks to the future. And then perhaps paragraph 36 is the crucial paragraph here. There's obviously a tension between the inability of the court to resolve factual disputes between the parties and the risks that the children will face if the allegations are in fact true. But that's in reference to an earlier observation of Baroness Hell, which is, I think I've taken my lords to very quickly, that oral evidence is rarely taken to decide the truth of allegations under 13b. But that's all matters under 13b. It's not limited to domestic abuse allegations. Mr Turner, my own friend, submits that there is a sensible and pragmatic solution. Where the allegations of domestic abuse are made, the court should first ask whether, if they are true, there would be a grave risk that the child would be exposed to the Article 13b risk. If so, the court must then ask how the child can be protected against the risk. The appropriate protective measures and their efficacy will obviously vary from case to case, country to country. So where arrangements for international protection between liaison judges are so helpful. Without such protective measures, the court may have no option but to do the best it can to resolve the disputed issue. I should say, just to make it accurate, that no one in this case was or is suggesting that the judge should have heard oral evidence in respect of Article 13b. My lords, thank you. Can I then take you on to my Lord Justice Moylan's judgment in Re A at page, starts at 276. So I should say in opening that both myself and my friend Mr Geoffrey were involved in this case for the applicant father. My Lord analyses the relevant law at paragraph 81. This was an American abduction and the Article 13b issues were around not only domestic abuse but the risk of separation of the subject children from both their mother and also a half-sibling who was a teenager and was refusing point blank to return. So the case was particularly concerned with that issue of separation in both relationships. My Lord Justice Moylan analysed the approach to be taken in Article 13b Article 13b cases, starting at 81 with the preamble. I didn't take my lords to paragraph 14 of Re E in the combined speech of Baroness Hell and Lord Wilson. Sometimes forgets it was a joint speech.
So sorry, Mr. Holmes, which page?
I'm so sorry, it's page 288.
Thank you.
So my Lord Justice Moylan sets the scene at between 81 and 82. At 84, I must remind myself that Lord Justice Moylan said it hardly needs restating in terms of Article 13b are by their very nature restricted in their scope, a high threshold demonstrated by the use of the words grave and intolerable. I don't propose to take my lords to the important Supreme Court case of Re-S that followed very quickly after Re-E. Then to continue at paragraph 85 over the page, focus of Article 13b is of course on the child, and I can move, I think, pretty quickly through 86 and 87. I should just perhaps deal at 88 with the particular issue in that case, which is a feature of this case, if not the main feature of this case, which is where Lord Justice Moylan analyses the effect of the separation of a child from the taking parent, which can establish the Article 13b risk. The situation is one of those decisions potentially falling within the scope of this provision. And my Lord refers to the Guide to Good Practice, which is in the bundle that I don't think has arrived yet. So I'll leave that for the time being. In Re W, this is the last sentence, Re W, my Lord said in the course of that judgment, that's an American separation case where there was in fact an immigration issue. And that was a prime example of where an immigration problem, where the immigration position of the children on the one hand and the mother on the other was different, that there was a risk of separation. And even where the situation was caused by the mother's own actions, again, I should add that I was acting for the mother in that appeal. But even if one characterised the mother's actions as deliberate sabotage, it doesn't matter because the focus is on the situation of the child. And then there's reference at paragraph 89 to a long-standing appreciation of the risk that can arise if the taking parent simply refuses or decides not to return. I'll come on to that feature dealing with the question of oral evidence later in my submissions. Then at 91, there is further analysis of paragraph 32 of Re-E and the crucial paragraph 36 of Re-E, which is where my friend Mr. Turner's sensible and pragmatic solution is analysed. And then at paragraph 92, and this we submit as a crucial paragraph, Lord Justice Moylan says, repeating what he said in Re-C, that it is not suggesting there is no evaluative assessment of the allegations. And he refers to a decision of Lord Justice Black in Re-K.
Lady Justice Black.
Sorry, what did I say?
Lord Justice.
I'm so sorry. I meant to say Lady Black, as she now is. Oh dear. I'm very sorry, my lady. That's an appalling mistake. Quoted what Lady Black, Lady Justice Black as she then was, had said in Re-K, that she had said, I do not accept that a judge is bound to take the approach if the evidence before the court enables him or her confidently to discount the possibility that the allegations give rise to an Article 13b risk. Lord Justice Moylan emphasises that Lady Justice Black was referring to discounting the possibility that the allegations would give rise to an Article 13b risk. She was not otherwise diverging from the approach set out in Ree. It is also plain that she was referring to the end of the spectrum, namely when the court was able confidently to discount the possibility that the allegations gave rise to an Article 13b risk. That is not, says Lord Justice Moylan, to dance on pins, but is a distinction of substance derived from the court not being in a position to determine the truth of the allegations relied on as establishing the Article 13b risk. My lords, we don't have that authority of Ree K specifically in the bundle, but if it would assist the court, I wasn't proposing to do this, but I can take the court to the passage in Ree C where the main paragraphs in Lady Justice Black's judgment in Ree K are cited. My lords, that's at page, my lady, that's at page 319 of this authorities bundle. Where Lady Justice Black's paragraphs 52 and 53 are set out. And perhaps at 53 is a little bit more detailed than the passage set out in Ree A. Mrs. Justice Hogg found that the mother's evidence about what had happened to be inconsistent with her actions, in that she had continued her relationship with the father and allowed him to have the care of E. She also put the allegations in context, bearing in mind what the Kafkas officer had said about something good having happened in E's parenting, which he took as a demonstration that he would not be at risk if returned to Lithuania. The Article 13b argument had therefore not got off the ground in the judge's view. And then Lady Justice Black explains why the Court of Appeal wouldn't overturn that judgment. So that's, in our submission, a useful illustration of where a court can safely discount the possibility of the Article 13b risk, which we say is not this case. My lords and my lady, can I then invite you to go back to Ree A and to continue where we were before, which is at paragraph 92 at page 291. Paragraph 93, Lord Justice Moylan comments that the judge has to be careful when conducting a paper evaluation of the evidence. The court has to be careful for the reason given by the Supreme Court at paragraph 36 in Ree E, namely the inability of the court to resolve factual disputes. That creates the tension identified between this inability and the risks of the child that the child will face if the allegations are in fact true. I haven't taken, my lords, to the concluding paragraphs of Ree E, but it's perhaps worth emphasising that the Supreme Court, paragraph 52 in that case, say that where there are disputed allegations which can neither be tried nor objectively verified, the focus of the inquiry is bound to be on the sufficiency of any protective measures which can be put in place to reduce the risk. The clearer the need for protection, the more effective the measures will have to be. I'm sorry, I should have perhaps taken my lords and my lady to that paragraph when we were looking at Ree E. then there's more analysis at paragraph 94 by Lord Justice Moylan in analysing, reading from the fourth line down of that paragraph, in analysing whether the allegations are of sufficient detail and substance, the judge will have to consider whether, to adopt what Lady Justice Black said in Re K, the evidence before the court enables him or her confidently to discount the possibility that the allegations give rise to an Article 13b risk. Then Lord Justice Moylan at paragraph 95 continues, a judge, and he repeats this just to hopefully ram the point home to judges, a judge must be careful when undertaking this exercise because of the limitations created by it being invariably based only on an assessment of the written material. A judge should not, for example, discount allegations of physical or emotional abuse merely because he or she has doubts as to their validity or cogency. In other words, if a judge can't decide or can't take into account whether he or she believes the person making those allegations. And the reason for that, as Justice Moylan explains, in my view, this would lead the court to depart from the Re process of reasoning, while equally not being in the position set out in Re K. It carries on at 96. So if the judge concludes that the allegations would potentially establish the Article 13b risk, the court then, just reading on to the fifth line, the court must carefully consider whether and how the risk can be addressed or sufficiently ameliorated. And then Lord Justice Moylan repeats the message from Re, which I've referred to above. And then at paragraph 97 we come to the two stools metaphor that I used at the beginning of my submissions. Lord Justice Moylan states, in my view, putting it colloquially, if the court does not follow the approach referred to above, it would create the inevitable prospect of the court's evaluation falling between two stools. The court's process of reasoning, borrowed from Lord Wilson, would not include either A, considering the risk to the child or children if the allegations were true, nor, little b, confidently discounting the possibility that the allegations gave risk to an Article 13b risk. The court would be rather adapting something of a middle course than falling between two stools. And the result of that, my lords, my lady, the judge is likely to be distracted from considering the second element of the Re approach, and namely, how the child can be protected against the risk which the allegations, if true, would potentially establish. And then at 98, the likely consequence of adopting this middle course is, in my view, that the court will be treating the allegations less seriously than they deserve. Equally, there is a danger that for the purposes of determining whether the risk, Article 13b risk established, the court will not properly consider the nature and extent of the protective measures required to address or sufficiently ameliorate the risk which the allegations potentially create. In my view, as explained below, this is what happened in the present case. And in our submission, that is exactly what happened in this case. And then, for the sake of completeness, paragraph 99 concludes my Lord Justice Moylan's analysis of the correct legal approach, which is self-explanatory. My Lords, that's all I want to say about the two stools approach. I've alluded to the approach of Lord Justice Henderson in Re P. Can I very quickly take my Lords to page 308 in this bundle, to a passage, the passage in his judgment. This was an Italian case where the mother had been, I think, convicted twice of child abduction and had fled England and it was highly likely that if she returned with the child to Italy, she would be imprisoned. Paragraph 59, just time, Lord Justice Henderson sets out his conclusion. With the greatest respect to the judge, I cannot escape the conclusion that he was unduly influenced by considerations of comity and the underlying policy of the Hague Convention, combined with the understandable wish not to let the mother profit from her deplorable behaviour, while paying insufficient regard to the predicament which was actually likely to face the child on her return to Italy with her mother, and which needed to be considered with some care on the alternative assumptions that the mother would or would not be imprisoned. And then he sets out the question whether the exception had been established on the evidence before him. Well, I don't. Can I then take my lords and my lady to paragraph 61? In order to decide whether the test was satisfied, it was, in my opinion, necessary for the judge to examine in concrete terms the situation that would actually face the child on her return to Italy. And then he further analyses the question on the facts of that particular case. My lords and my lady, while we're on this case, can I just take the court very briefly back to paragraph 58, previous page, which is a paragraph dealing with specifically with the question of the mother's possible imprisonment. I say this at this stage because I know it's a point that Mr. Turner makes. There's the decision of Mr. Justice Wilson, as he then was in Re L, where he ordered the return of 3-year-old twins to Florida following their abduction by their mother. In that case, the mother relied on the risk that she would be prosecuted in the United States. In support of her Article 13b case, Mr. Justice Wilson still ordered the return. Lord Justice Henderson observes that he found this case of little assistance. However, given the very different factual circumstances, in particular the father in that case, that's Riel, had produced evidence from the prosecuting authority that, subject to conditions, he would strongly recommend that the Court of Florida should grant the mother bail. Further, Mr. Justice Wilson saw no reason to suppose that, in deciding whether to continue with the prosecution after the mother's return, the state prosecutor would exclude consideration of the interests of the children, or that the judge in Florida would do likewise. Conversely, in contrast to the case that Lord Justice Henderson was dealing with, the present case, the mother is already subject to a sentence of 1 year's imprisonment, which has been recently upheld on appeal. And it's now the second occasion she's unlawfully abducted her daughter. In this case, the factual position is that there is still a denuncio which the father caused to be issued immediately after the abduction, and it's still there, it's still in place. My lord, can I then analyse the judgment itself, please, my lady? This is in the court bundle, please. It starts at page 62. But for these purposes, Article 13b, here the learned judge's analysis starts with an exposition of the law, page 71, paragraph 69, which I don't propose to go through in detail because I don't criticise the statement of the law of those paragraphs. Just observe that that's the section where he sets it out, particularly borrowing from another decision of, I think, Lord Justice Baker in this court, Can I then take my lords, please, to the analysis of the Article 13b risk that the judge commences at paragraph 112 of the judgment, which is at page 79 in the bundle. I hope I can take this quite quickly because my lords now have I hope, a flavour of our factual case and we say the relevant legal principles. So 112, the judge sets out the Article 13b case. Little 1, little 2 dealt with the uncertain immigration status, their necessities, separation, and then abduction in Morocco, which I don't press in this appeal. He then says he considers all 5 reasons below and then asks himself what, on the face of it, appears to be the right question. It's our submission that he then doesn't actually conduct an analysis that is consistent with that question and therefore comes up with the wrong answer. He then analyses what he considers to be the mother's case at 115, but going over the page. At little 3, he says he would look, he states that one of the mother's allegations that he would lock her in the house. He then goes on at little 4 to say he was controlling with the children too and would lock them in. Little 5, became physically abusive when the children were taken into care. And then little 6, the children also were locked in the house with the mother. And they got control and abuse there. Little 7, continue to send abusive measures, but she does not have any record of these. And my lord, that's perhaps the first alarm bell in our submission. As if the judge is saying, well, I can't believe it because there aren't written messages, but there are other matters that we draw to your attention. And then there's little 8, the threat to kill. I'm going to come back to those paragraphs shortly. But over the page, when he is considering in concrete terms the situation would face the child, he is then internally inconsistent in our submission at little 2, where he states, we would submit in contradiction to what he had said just a page earlier, that the mother has not made allegations that the father has been physically violent or abusive to the children. My lords, can I then go back, please? I'm sorry to jump around like this in my lady. Paragraph 116 deals with the obvious point that the mother didn't tell the social services everything, and in particular when they were either taking the children or returning the children from care. He then provides the explanation for that. 17, he notes that the father denies the allegations completely. Whilst that's part of the background, in our submission it is only a minor part of the analysis because the court has to take the mother's allegations at their highest if there were truth, because the court cannot resolve the truth of the allegations being made by someone relying on the Article 13b. But paragraph 17, we would submit, is a clear example of the judge failing to adhere to Lord Justice Moylan's warning of not to determine the cogency or the validity of the mother's allegations. And we submit this paragraph does not come into Lady Justice Black's exception, as we would characterise it. I've dealt already with the 118 conflictive relationship report allegedly made by the Spanish social services. We make the obvious submission that just because the mother didn't report that she was in a controlling relationship or that the father was being violent cannot and should not have been taken, as we submit it was, by the judge, as doubting the validity of her allegations. And paragraph 120, and this we say is a crucial paragraph. In evaluating the evidence, I note the lack of detail about any of the allegations, none of which are dated other than the recent threat to kill, or reported to any third party other than social services in Cornwall. We submit that is what the judge is not supposed to do. That cannot be read in the context of what Lady Justice Black was stating was permissible. By making those points, he is not and should not, and if he was wrong to discount the possibility that the mother's allegations would give rise to an Article 13b risk. What he's doing there is determining the cogency and the validity of her allegations, which, as Lord Justice Moylan has pointed out in his judgments, he should not do. Paragraph 121, alluding to Lord Justice Henderson's expression adopted in subsequent authorities, he simply says, without really giving any reasons there, but I'll come to the reasons he gives over the page, his conclusion for not considering that they, the mother's allegations, reach the high test of grave risk. The simple point we make is all those matters listed at paragraphs 112 and 115, you can take into account 115 in its entirety. He should have been readily satisfied that the allegations, if true, did give rise to an Article 13b risk. He then sets out his reasons over the page. Of course, the reasons must be read with the conclusion. I've already observed that little 2 is simply wrong. And here he's falling between the two stools. He's evaluating, on the one hand, he's evaluating the allegations, and on the other, he's considering the protective measures. It's, in our submission, a prime, almost with respect to the judge, textbook example of a judge falling between the two stools. Paragraph 122, he deals with questions of enforceability, which is only part of the analysis of protective measures we would submit. He's got to also decide how effective any such protective measures would be. He plainly has in mind the undertakings that the father had offered in little 4 in respect of this topic. My lords, and my lady, I should have drawn your attention to subparagraph 5, because this is an important factual point here. But the judge records that the mother invited the father to move close to her in England and have regular contact with the children. We have carefully looked at the father's witness statements. That is not evidence that he gave in the witness statements. Mr. Heifer recalls that it was something that arose during closing submissions. The judge, and we don't have any transcript of this, but I'm just telling you what Mr. Heifer tells me, did not call on Mr. Heifer to deal with this issue. Our submission to this court is that that is something that the judge should not have had regard to because it was not evidenced. And it should not have been used to dilute the risk. That's what he was referring to. And it should not be used to minimise the important need for protective measures, if that is what he is referring to. my lord, I'm studiously not going to tell you what the mother's reaction to that allegation is, because that isn't evidenced either.
The judge refers in paragraph 118 and again in 121.6 to the father as having been identified as a protective factor. And you took us earlier to the reference to that.
Yes.
And you say there's no other reference anywhere in the documents as provided by the Spanish authorities to that.
Mm. Yes.
Thank you.
Going back to 123, the judge said that he'd seen no evidence that the mother would be unable to access justice in Spain. Well, there was in the social services report, which ironically the judge then goes on to analyse when he considers the question of immigration status, paragraph 131, which I'll come to very shortly. My lord, then he announces that his conclusion, I do not find that the allegations of domestic violence reach the threshold. My lord, again, with respect to the judge, it's falling between the two stools. And he was wrong. The allegations did reach the required threshold, and the judge should have considered far more carefully than he did. And without conflating the issues, what protective measures would protect the children against the risk, and would they be effective? My lords, I don't, in fact, need to make any further points in respect of the ensuing paragraphs, but 131, the judge sets out in this section of his judgment, this is dealing with the immigration aspect, some of the work carried out by Spanish social services to assist the family on residence permits specifically. And this is very detailed, and it's to the credit of the Spanish social services that they carried out this work. Over the page, in summary, 133, the list also demonstrates just how much work was carried out by social services in Spain. Neither of the parties referred to the work. My lords and my lady might think, perhaps unsurprisingly. And he notes that the family will have an allocated social worker. What the judge did not analyse earlier when considering the issue of paragraph 123 would be that this was prime evidence which went to his, or should have gone, to his analysis of the effectiveness of protective measures. I've already submitted that this mother is vulnerable, and without further analysis, the court should not have assumed that she would have the wherewithal, the personal, the financial resources to access really anything in Spain, let alone complicated court process, finding lawyers. And that's when her Spanish is, by its nature, only her second language. My lords, as far as immigration is concerned, my lord, the judge below 137 cites a decision of Mr Robert Peel, QC, now Mr Justice Peel, who simply observes that immigration difficulties, which are relatively common, do not by themselves establish the Article 13b defence. Well, that doesn't really say anything other than how common they are. It doesn't mean they don't arise, and my lords have already been taken to a case, not explicitly, where immigration has been a factor, and it's not a satisfactory riposte to a case based on a difficulty with immigration simply to say that it rarely occurs. The judge's evaluation of this issue, we would respectfully submit, again, is hopelessly flawed. Just because paragraph 139 just because she was living post-Brexit in Spain, does not address the real difficulties that the children and her would have in staying and living in Spain beyond what I've already submitted is the length of the tourist visa. Paragraph 140, the Spanish judicial system, I've already made a general point about applying to that, but I think it's almost self-evident that the judicial system of the state doesn't deal with questions of immigration. And really it's not an issue for the judicial system, as the judge seems to suggest at paragraph 141.
Did that sort of come out of a submission? Do you know where that observation came from?
I might have to turn my back, I'm afraid. I'll just do that. I'm sure in due course I'll be corrected if I'm wrong, but Mr. Heifer tells me that it was a point made in submission by Mr. Bennett on behalf of the father.
As bald as that? Or we can find out, well, maybe it will be expanded on. Okay.
But it wasn't evidentially grounded. I can't recall whether it was in Mr. Bennett's position statement for trial, position statements for trial. But we can look at that if it's an issue. My Lords, then, basic necessities and financial provision at 142. The judge rightly recognises that it's the mother's position that they've moved to an unstable environment. I haven't taken, my Lords, to why I say that. It's a document at page 169. Please, perhaps I can ask the court to go to that. Sorry, this is a slightly different point. 169 is a document that is dated the 4th of May 2022. You can just see that in the top left-hand corner, the wrong way round. This is a letter from the Spanish authorities to my lady, Mrs. Justice Arbuthnot, pointing out that the parents were unemployed at the time. And this is a letter referred to, this is a report referred to in the letter that I do want to take my Lords and my Lady to, which is at 198. So I'm taking this very shortly. There's a lot more in that report that others might take my Lords and my Lady to, but for my purposes, can we go please to 198, which is a document that must be subsequent to the report of the 4th of May 2022, because it says, see the report previously sent on the 4th of May 2022. The important paragraph is 3 paragraphs up. If the family does not have accommodation with the basic conditions of habitability and equipment, social services could respond for the children minors. If it considered they are in a situation of possible vulnerability, having to adopt child protection measures, foster care in juvenile centres. That was very much at the forefront of the mother's mind. She is deeply concerned, in our submission for good reason, that if she does find herself, as it were, destitute, that would be the reaction of the Spanish authorities. Can I then invite the court to go back to page 84, please? The court introduces the issue. 142, 143 records my learned junior's submission that they're not just practical considerations. Financial instability, unless ameliorated, could amount to an Article 13b risk. Again, it's our overarching submission that in his analysis of this topic, again, the judge falls between the two stools of, on the one hand, evaluating the risk, and then on the other, determining protective measures, without looking at the position that the children would confront if they were to be returned. There's an issue in 44, the unstable life in Spain. There's an issue, it's a feature. There's an issue at 145 about whether or not the mother would be entitled to benefits. I've already taken my lords and my lady to a reference where she was not getting, she said she wasn't getting benefits. Her case should be looked at as if it were true. There was some evidence of assistance from a family friend. It's right that there is a passage in the Spanish documents that I don't propose to take my lords and my lady to, but for reference it's at page 172, which does say in terms that there was an English relative who was prepared to offer and was paying €800 a month. Looks like she had been in contact with the Spanish social services, and it indicated that she would continue that. Our submission is that any assistance on the part of this thank you very much. Was very fact specific and also time specific, and could not be, and in the absence of any further evidence from the parties, and this doesn't again feature in the written evidence for this court, the court should have been far more circumspect. Generally, we submit in respect of finances that although the father has made all the offers that the judge analyses, what is singularly lacking from this analysis, and I going all the way over to paragraph 161, is any analysis of the effectiveness of the father's proposals to ameliorate the risk of impoverishment. The mother, as I've taken the court to challenge the father to produce the evidence. The only evidence that the court has got is from the Spanish social services, that both parties are unemployed. No evidence that he's got a job, no evidence that he's got income. Mother's case, he never supplied regular support before them. That's why they got into the whole predicament in the first place, and why the children were removed into care. My lords, my lady, paragraph 158, the judge below attempts to distinguish the Lord Justice Henderson case of GP and P, but in our respectful submission, that's besides the point of what my lord, with respect, was saying in that case. But that case simply wasn't a case where the mother was facing homelessness, she was facing imprisonment. But we don't understand the point that he was trying to make there. At paragraphs 160 and 161, the judge deals with the mother's real concern that the children would be removed into foster care. My lords, even if the work carried out by Spanish services historically was extremely extensive, it doesn't deal with the issues that the mother raises about financial impoverishment. All that the Spanish authorities seem to be prepared to do is to take the children into foster care. My lords, the next section deals with separation, specifically in respect of the denuncia. My lords, just looking at the next few paragraphs to 169, he discounts this risk with a reference to my Lord, Mr Justice MacDonald at paragraph 168, relying on re L and re C, without referring to the very real distinction that I took my Lords and my Lady to in the judgment of Lord Justice Henderson in re P. That, again, he can't analyse this case by resorting to what generally might happen in these cases. Generally, in some cases, it may be right to follow the approach of Mr Justice Wilson in the 1999 case. In other cases, it's not, as in the case which Lord Justice Henderson was dealing with. There's then a conclusion at paragraph 169. We accept that to some extent it would minimise or it would reduce the risk if the father, as a condition of a summary return, provided evidence that he'd withdrawn his consent. But we submit that that wouldn't be enough, given the, go back to an earlier theme, the cumulative impact of the mother's case, and particularly bearing in mind her particular vulnerabilities, which has an important consequences for the children themselves. My Lords, it's right for me to observe that 178, the judge does impose that condition that I've just taken my Lords to. Well, that's all I have to say about Article 13b. Can I then go on to deal very, I hope quickly, with the other important ground that we rely on, which is the question of oral evidence. It's right that the mother's case was very much that the father had clearly and unequivocally consented to the removal. She said that he'd already done that, and that's why they applied for passports and why father applied for a visa, and she denies his case that he had withdrawn that consent. I make those points bearing in mind that the focus of our attack is on the absence of oral evidence. Can I go to the judgment, please, at page 63. Where the judge deals with this at paragraph 9. Yeah, I should observe that I think it's common ground that we don't have a transcript of that extempore judgment. But Mr Heifer assures me that the matters set out in the preceding paragraphs up to and including paragraph 17 effectively encapsulate what's contained, or what would be contained in that transcript if it were available. He refers, and this is very much the topic of the intervention, so I hope I can be brief. Just to analyse the judgment, the judge refers to the authority of Mr Justice Mostyn, that the relief is an interim procedural nature, proceedings of summary. Oral evidence is very much the exception rather than the rule. That perhaps doesn't quite encapsulate what the test is, but I'll come on to that in a moment. Mr Justice Mostyn observed there's no obvious reason why Article 13b defences should not include oral evidence, but defences of consent and acquiescence under 13a should be heard with oral evidence. That's what Mr Justice Mostyn says, or is reported by this judge to have said in ES and LS. It's right that Mr Justice Peel agreed with the views of Mr Justice Mostyn in another case, which I'm going to come to. And then he refers to another first instance decision of Mr Justice MacDonald on its facts, where he in fact refused an application to hear oral evidence in relation to consent. it's right to observe that both Mr Justice Mostyn and Mr Justice Peel did in fact hear all evidence. Mr Justice Mostyn, and I'll leave it to others to take you to the authority, does not, in fact, allowed oral evidence in respect of child's objections and only on the only cross-examination of the Cathgas reporting officer. Mr Justice Peel, in his case, again, allowed oral evidence on the issue of consent, but simply made it would make no difference. Mr Justice MacDonald ruled in his case that he did not need to hear oral evidence in relation to consent. Again, on different factual circumstances where he had sufficient material to deal with the question or the issue of consent. Can I perhaps just take my lords to that decision, because it is a consent case where oral evidence was not ordered. My lords, it's at page 152 in the main bundle. And paragraph 3, it's a very short point on the facts of that case. Paragraph 3, father replied, that's the respondent father, so he was relying on the issue of consent in the same position as mother was in this case. He applied to hear all evidence. The court has before it extensive written evidence, and quite how extensive is then explained. And Mr Justice MacDonald announces his decision in regard to the rarity which the court will accede to applications to permit oral evidence. He declined to permit oral evidence, satisfied as I was that the court had sufficient documentary evidence to determine summarily the issues before it fairly. And paragraph 46, he deals with his analysis of the consent and acquiescence issue. If I could take my lords to page 166. And very, very, very briefly, you can see the way the judge in that case analysed the case. The father exhibiting, this is 47, the father exhibiting to his statement emails inquiring about education in a London public school. And there follows, and I don't need to take my lord to the detail of this, analysis of the written material. My lords, our point is a very basic point, that there is no written documentation in this case. It's all governed by oral evidence. My lord, there are, without descending too much in the detail, we submit that there are a number of issues that the judge would have been assisted by oral evidence to determine what was actually discussed and agreed between the parties, both at the time that they decided to move to England and if any subsequent discussions that the father might rely on to prove or to indicate that he had withdrawn his consent.
Mr. Hames, I'm a newcomer to this jurisdiction, but are you using withdrawal of consent as a term of art? Because speaking for myself, it seems very odd to say that if a parent agrees that the family are going to move to England as a unit, but then that becomes impossible because the father doesn't get a visa, that he must be taken to have consented to the mother removing the children to England without him, unless the contrary is proved.
My lord, it's the use of the word must. It's not a rule of law, but it's one of the matters that the trial judge needed to investigate and should have investigated. And it may be that on hearing all evidence, he would not be satisfied that the father had withdrawn his consent. It may have
Consent to what?
been to a removal.
Well, consent to removal just as a physical act, irrespective of whether they move as a family or without him.
Well, that's the mother's case.
The mother's case is he plainly agreed at the time of the application for passports and visas that they would all move to England.
Yeah.
And you say the subject was never discussed again. That's it.
Well, there's no evidence other than my mother's evidence. I mean, I can just deal with the mother's case. And I think, take my lord to that part of her statement where she says that the father, as part of his campaign of abuse, locked the mother and the children in the home on the day they went, then came back, unlocked them and said, just go. My lord, the other answer to my lord's case is to take my lord to the legal test, which happily has been authoritatively summarised by my Lord Justice Peter Jackson in a case called G&G.
Yes.
And I'm not going to do anything other than take my lords to the summary. In that case, at page 142. And paragraph 25. And it's all, I refer to all of that paragraph, but just underlining some important factors. It's fact-specific. It has to be clear and unequivocal, the consent, but it's not viewed in the context of the law of contract, common sense realities of family life and family breakdown. And we would add the vulnerability of the mother in this case. It's the reality of the family situation. And a primary focus is on the words and the actions of the remaining parent, father. Words of actions of the mother in this case may also be a significant indicator. The consent must be clear and unequivocal, may be manifested by words and or inferred from conduct. I emphasise the passage before that. It does not have to be given in writing or in any particular terms. On the one hand, I add, a person may consent with the gravest reservations, but that does not render the consent invalid if the evidence is otherwise sufficient to establish it. Consent must be real, in the sense it relates to a removal in circumstances that are broadly within the contemplation of the parties. And that's, my submission, an important point, and I hope helps answer my Lord's question. Consent would not have been given but for some material deception or misrepresentation. I don't think that's been alleged here. Consent must be given before removal. Advance consent may be given to removal at some future but unspecified time or upon the happening of an event that can be objectively verified. To be valid, such consent must be operative at the time of the removal. And then subparagraph 8, which was a particular feature of the case before Lord Justice Peter Jackson. The consent can be withdrawn at any time before the actual removal. The question will be whether, in the light of the words and or conduct of the remaining parent, so the father, the previous consent remained operative or not. And there's an ancillary point to that. The giving or withdrawing of consent by a remaining parent must have been made known by words and or conduct to the removing parent. consent or withdrawal of consent, of which removing parent is unaware, cannot be effective. My lords and my lady, just going back to this case and what we submit on the evidence, the court would have been assisted in determining, by hearing oral evidence, are the very points of what was discussed, when it was discussed, what were the terms. Unusually, I say this with some pleasure, this case does not have mountains, reams of social media extracts that advocates, judges, this court have to trawl through. It's completely absent. So those crucial communications only happened orally. And we submit that that is a crucial point that the judge should have considered and was almost by itself a reason why he should have taken oral evidence. But there are other issues that can only be determined, we would respectfully submit, in some of the detail. And this list is not intended to be exhaustive, but illustrative. A mother says bags were packed. Not sure what the father's position on this is. There's all sorts of issues that relate, that proceed from that. What bags? How many? What goods were taken? What possessions were taken? What possessions were left behind? There's an issue about whether, in fact, the mother arranged for the father to get a new job on that day. He says that in his statement, his evidence. She denies that. She says she wouldn't have been in a position to tell him to do that. And anyway, she understood that he'd done some work for this person before. There's then the dispute about whether, in fact, and this is just on the issue of consent, he did come back, or he did lock the children in, then come back, let them out and say, you can go. Did the father change his mind when his refusal was refused or not? We submit very strongly that he did not change his mind. Father, no doubt, will say that he did and communicated that. But there's nothing in the written materials. It's just oral assertion on the part of the parties. Was the father, or what was the extent that the father was concerned about the children being removed into care? Mother says that was one of the motivations for him suggesting that, in fact, she should give birth to B in England, wholly independent of whether or not he had been granted a visa. There's an issue that I haven't otherwise drawn the court's attention to as to whether the father said or did not say in December 2021 that the mother says that she could remain in England. I'm not relying on that for acquiescence, but simply one of the factors that could be tested by oral cross-examination. I'm sure that isn't exhaustive, but those are the type of issues that could be considered by the giving of oral evidence. My lords, re-see a recent decision of this court, of the President, deals with, and it's a page, starts at page 79, deals with the issue of oral evidence in a different context, I accept. But nonetheless, we would suggest it is the latest word from this court on the issue of oral evidence. The issue in this case, in contradistinction to Re A, was that the trial judge below had found that the abducting mother, she was the respondent, her assertion that she would not return with the child to France was not genuine, and he found that she would, without hearing oral evidence, because, as will become apparent, no application below was made for oral evidence. It's page 96, paragraph 59. And on the question of whether the judge fell into error by not requiring mother to give oral evidence, it is clear that there's no reported authority on that point, and that point being the mother's assertion that she would not return. Hague Convention proceedings are summary and say where it is necessary to do so on issues of habitual residence or consent and acquiescence. Oral evidence is not adduced. And then dealing with the facts of that case, neither party either applied for or even suggested the mother to be called to give oral evidence. Against that background, very difficult to understand how the judge could be criticised. In addition, I do not accept Mr Gupta, who was acting for the appellant mother, premise that any oral evidence the mother might have given would have been short. On the contrary, it would seem likely that if the mother were to be asked why, she would list all her complaints about the father's past behaviour. In this case, that was specifically factored in. Mr Heifer tells me when, and I haven't referred in my oral submissions to this, the case came before the same deputy judge on an earlier occasion and was re-timetabled to a different date to allow the mother to file a statement. And oral evidence was specifically factored in, so that if the judge had decided to take oral evidence, Mr Heifer tells me the case would still have been, or was still planned to finish in the time estimate. So that is plainly an important factor, but was not a crucial factor we would submit in this case.
Well, that's in a sense almost a passing reference. Although, there are cases far older than that deal with RECA as well, that deal with the issue of oral evidence, in particular in respect of consent. And I think Mr Sepright has referred to what Lord Justice Thorpe said in RECA, that classically oral evidence would be limited to cases of consent. And research is undertaken by our judicial assistant have identified a decision of Mrs Justice Porfley's from 2015, in which she said it's customary to permit oral evidence at summary return hearings where consent and acquiescence are in issue.
Yes.
That was WA in 2015. I'm not sure it's reported. So that's the sort of history of the court's approach to oral evidence, in particular on the issue of consent.
Yes.
And indeed, Mr Turner in his submissions recognises that there is a difference between issues such as consent and Article 13b.
Yes. My Lords, yes. We, in the, perhaps don't need to take my Lords to it specifically, but there is in the new bundle of authorities that my Lord has just received an interesting example, and I put it no higher than this, of Mr Justice Holman directing that there should be oral evidence even in Article 13b case, where he was confronting the same issue that the court in Re C had to deal with, namely whether a mother's refusal to return in the event of a return order was genuine, or whether she'd in fact changed her mind. And he did hear oral evidence in order to be fair to the mother. My Lord, that's at paragraph 21 of that decision.
Which one is it?
NP and DP. It's a comparatively new
NP and DP.
DP.
And the other question I was going to ask you is that we've been given in this new bundle the practice guidance, which was issued by the President in March 2018. That is in the course of being reviewed.
Yes.
And what I'm not clear about is whether the draft amended practice guidance or proposed is a public document. I would have thought it's been sent out for consultation. Yes. I know that.
My Lord, we made some inquiries of that, and we understand that it is with a judge, a specific judge, for consideration, Mr Justice MacDonald.
Yeah, but there's a committee that he set
Yes.
up to consider it, and it was sent out. I know it's been sent out for consultation.
Yes. It's not a public document yet, is our intelligence.
Right.
I'm very happy to be told that I'm wrong about that. But that's as we understand the
Right.
position, having made certain, but by definition, rather limited inquiries.
Right.
You say it's been sent out consultation. Is it just to a select group of recipients or to the general public? Just to set right next.
My Lord, I rise to make a confession,
Yes.
which is that I received it for consultation. But I have treated it, out of an abundance of caution, as not being a public document, and so have not passed it on to anyone. But nobody told me one way or the other.
Well, for completeness, I've not seen it.
I think Mr. Bennett was about to say something.
My Lord, yes, I have seen it in the context of the children law orders being revised, and I have been told expressly that I was to receive it, quote, in the strictest confidence.
Right. Okay. Thank you.
Right.
Right.
Well, then we're not going to refer to it.
No, my Lord.
Mr. Hames, I'm just looking at the clock.
Yes.
It's 20 to 1.
Yes.
We didn't inquire at the beginning of the day how we were going to spend the day, but one sort of assumes in the sort of case that it was going to be you this morning, and then this afternoon, Mr. Turner, Mr. Setright, and your reply. Was that a correct assumption?
In fact, I was hoping to have concluded by about now. I can certainly make myself conclude by lunchtime.
Well, I hear
Yes.
that
Don't
would
take
seem...
longer than you
Yes, don't feel obliged
Don't-
to speak for another
Yes,
19 and a
just
half
to fill
minutes,
the
but
time.
Wouldn't dream of it, my lords,
No.
my lady.
very well. All right. Well, you know what your plans are, but
Thank
we think you ought to finish by the...
Thank you, my lord. I totally accept that.
Right.
My lords, my lady, I think I was taking the court to a first instance decision of Mr Justice Holman, MP and DP,
Which is
which
where...
is page, it's a page, I think, 185 in the supplemental bundle that you've just been handed.
Yes.
This is a case where my friend Mr Turner and I, again, locked our swords. Just to set the scene, there'd been this had been, according to the judge, a bad abduction where the mother had gone to ground. But the issue for the judge is, as I've said, whether the mother's avowed refusal to return to the United States, if a return order were to be made, was simply an assertion by her to defeat the claim, or whether it was genuine. Of course, if it was genuine, on the facts of that case, there would have been an Article 13b risk based on separation of the child, because a consultant psychiatrist had said it was disastrous and catastrophic for that particular child to be separated from the mother because of his own particular difficulties. You'll see that that's introduced at paragraph 19, and I could not and did not submit that risk wouldn't arise if the mother didn't return. So almost the sole issue in the case was whether the mother would return or whether she wouldn't. It was said on behalf of the father that of course she'd return if the court made an order because she would want the best for her child. Said on behalf of the mother that she would refuse to return for reasons that were explored during the oral evidence. And you'll see the approach of Mr Justice Holman sets the scene at paragraph 19, and he did actually hear evidence on, for various reasons, on two separate occasions. The reason for that is that he wanted her to deal with further protective measures that had been put forward by the father between those two separate occasions. And he referred to the authority of Re C and deals with the case at paragraph 121 and explains why he heard targeted evidence, as he calls it, from the mother not once but twice, and deals with it, his reasons at perhaps the last sentence. He found ultimately that he would personally consider it potentially unfair and unjust to make a finding against a parent on an issue such as this without, if she wishes, the respondent wishes, permitting her orally to explain her state of mind and intentions in her own way and for herself. I include that just by way of illustration of how broad, in fact, the discretion to hear oral evidence is in fact exercised by the High Court. And this is a prime example of an unusual case, but perhaps not so unusual. It's not, as the appeal in both Re A and Re C, and in this case, all touched on an issue of separation from the removing, abducting respondent mother, either not being able to or refusing to return. And this is an example of a very experienced High Court judge considering it fair. And that seems to be the main reason he gives fair for the respondent to go into the witness box. And we would respectfully submit that that is exactly what the present practice direction on oral evidence is addressing. Yes, it's unusual. Perhaps I should take, before I make the submission, I'll take my lords to that practice direction, which starts at page 80 in the new bundle that my lords and my lady have. It's introduced perhaps at page 85, that little G. So I'm going to take this as quickly as I can. One of the directions that needs to be considered at the first on notice hearing is directions in respect of oral evidence, if appropriate. So that's got to be considered. The first direction's appointment. It's considered further at paragraph 3.8, where oral evidence is dealt with head on. Under subheading D, the court will rarely make a direction for oral evidence to be given. In our submission, that doesn't assist a court in determining which of those rare occasions that it would be appropriate to hear oral evidence. Any party seeking such direction for oral evidence will need to demonstrate to the satisfaction of the court that oral evidence is necessary to assist the court to resolve the proceedings justly. Any party seeking to rely on oral evidence should raise the issue at the earliest available opportunity and no later than the pre-hearing review. My lords have Re K, Lord Justice Thorpe and Lord Justice Mumby, as he then was, which I won't refer my lords to as setting out then the guidance. Of course it's rare. But in our submission, that practice direction encapsulates really two elements of when oral evidence might be directed. Firstly, that it's necessary from a forensic viewpoint for the court to be able to determine the issues. And secondly, to deal with the issues justly or fairly. And at the end of the day, in the final analysis, in our submission, this judge, for both reasons, should have heard oral evidence, both so that he could make a proper determination of the evidence that, by hook or by crook, was not contained in written documentation, but was simply oral discussions, and I've already made that submission. But there's a second element as well, which is to deal with the case fairly. It's not fair in our submission for this mother, given her vulnerabilities, given the nature of the case, not to be able to explain some of the issues that I've already outlined. My lords, my lady, the final authority that I propose to trouble you with is now quite an elderly case of Re-F, which is in the supplementary bundle at page 170. Mr. Setright is looking daggers at me because he was involved in this case in 1992. All right, the report's 92, it's even 91. This is a decision of Lady Justice Butler Sloss. She then was, and it's just the point dealing with oral evidence at page 174. And you'll the submission of Mr. Ross Munro, who represented the father, submits that in a case under the Convention, the issue where the child was habitually resident and a conflict of evidence on the issue which goes to the jurisdiction of the court ought to hear oral evidence. Lady Justice Butler Sloss comments that summary in nature, designed to provide a speedy resolution of disputes over children, secure the prompt return, deals with the procedure that there then was, and points to the danger that if oral evidence is generally admitted in convention cases, it will become impossible for them to be dealt with expeditiously. The purpose of the convention might be frustrated. Well, it's one thing again to express the generality. It doesn't assist in determining when it is appropriate. What she then goes on to deal with is what the approach of the court should be, where they're on the face of the written materials. There is a conflict on the oral evidence, or as she puts it, irreconcilable issues. Then dealing with affidavits. In that case, the law was different in respect of habitual residence, as it now is, and again, making a general observation, it was generally more usual to take oral evidence in habitual residence cases where the issue of parental intent was an important issue. It no longer is such an important issue in habitual residence cases. But in that case, the disputed evidence, as my lords and my lady will see, goes to the heart of the issue to be resolved. And deals with what had happened in that case. And then going on about halfway down the page, the sentence starting, having said that, well, there's no letters in this judgment, having said that, the task of rejecting the sworn evidence of a deponent on contested issues of fact without hearing oral evidence, and in particular cross-examine on the affidavits. There's no material difference. We would submit the fact that these are signed statements that are now used. I go on, is not one likely to be undertaken where in a case such as this, the resolution of the disputed facts is crucial to the decision of whether the convention applies at all. Now, except that that doesn't go to an Article 13b issue, but nonetheless we would submit that that principle expressed way back in 1991 is still applicable today. She then goes on, if the facts in issue are not crucial, oral evidence would not be necessary. If both parties are present in court, the father wasn't present but he can give evidence by video link, some limited oral evidence relevant to the issue would clearly be helpful in certain cases. Then she says, with hindsight, it would have been helpful in this case. We adopt this court to say more than that. But the admission of oral evidence in convention cases should be allowed sparingly. We don't dissent from that general proposition. But then the court goes on in that case to consider what a judge should do when faced with irreconcilable evidence and no oral evidence. And then the task is to look at independent, extraneous evidence in support of one side. and then she goes on to analyse the type of evidence that may be present. And then over the page, if there are no grounds for rejecting the written evidence on either side, the applicant will have failed to establish his case. In this case, that would be the respondent, because the burden of proof in consent is on the respondent. Adopting that reasoning, we say, in fact, there is no or very little reliable extraneous evidence that the court could have analysed in this case, and therefore there was no proper basis for rejecting the written evidence without oral evidence. Of course, it would have been comparatively straightforward for the judge to have made a determination if there had been oral evidence. And I'm coming to a conclusion now. When one looks at those 8 or 9 paragraphs in the judgment, in our submission, the judge simply doesn't deal with why it would be necessary, why it would be fair to determine the case fairly, or why it would be appropriate to reject the written material of either party, but particularly the mother, as she was making the running on the issue of consent. My lord, my lady, can I quickly turn my back? Just remind the court that the mother, I think I took my lords and my lady to this in the statement, says that she did have some messages, but she had lost her phone and changed her phone.
Changed.
Disposed of it because of the
Yes.
alleged abuse.
Yes, not thrown in the sea like some other people have done. Serious point is that the father too could have provided written materials, but for whatever reason he didn't. Right, unless I can assist my lords and my lady, those are my submissions in support of the appeal.
Thank you very much, Mr. Haynes. Mr. Heifer? Shall we say 5 to 2? 5 to 2.